Hi guys, I know I've had to go early. Something's happened, so I've had to come early rather than late. So because I didn't know how long it was going to take, and I know Emily's still on. I know Uncivil's about to start, so that's fine. This will be here for when you're all ready to watch, because after all, they are lawyers. I'm here just for the sass. Let's be honest. I'm here just for the sass. So anyway. So let's get started. Let's get started. And as I said, if I don't see you, I hope you'll have a great day. Because at the moment, there's nobody here, which is fine. Okay. So this is the plaintiff's response to defendant's motion to qualify and an oral argument. Hey, Frank, yeah, I'm going to do this stream, and then I'm only going to read the documents and get off again because I'm on a limited time frame. So we'll see. All right. Saltzy had to file early on the one day that I work. To be honest with you, it was like, really, Saltzy? Anyway, so introduction. Before defendants have even filed an answer admitting or denying any of the allegations in plaintiff's complaint, attorney Michael P. Brown and defendants are seeking a blanket order from the court that Mr. Brown and his law firm cannot be disqualified now or ever as counsel in the instant litigation or future proceedings in another forum based on his contact related to non-party witness Laurie Ann Barnhart. Number one, defendant's motion to qualify. So we've got lots of footnotes here, which is always helpful. Defendant's motion to qualify should be denied because such a motion is inappropriate. The issue of disqualification is not yet ripe. Discovery stayed. The totality of the communication between Mr. Brown and Ms. Barnhart is unknown, and the requested relief is overboard. Nor the plaintiffs obligated to file a motion to disqualify at this point of the proceedings. Well, they've yet. He's jumped the gun, Mr. Brown, and now he's been left with. Now the judge has a dirty mess to clean up. Defendants fail to cite any legal standard for a motion to qualify, nor do they cite a single case in which a party has successfully requested such relief from court. Perhaps this is because it appears no such case exists. The lack of such case is likely because once admitted to practice before a court, attorneys are not required to then affirmatively prove they are qualified. Rather, counsel is presumed qualified and are eligible to practice before this court until one, counsel withdraws, or two, counsel withdraws. So he's got down here local court rules. Hey, Angel Barnett, how are you going? I hope you're doing well. This is just very, very quick. So, hello, Stephanie. Says, I've been watching for a while, never caught you live. This is a disaster. Yeah, I know. It's a disaster. So until counsel withdraws, so local laws, withdrawal of attorneys, or the court exercises its duty to examine charges of conflict of interest brought in a motion to disqualify and determines the counsel is disqualified. See FMC text. So we've got more footnotes. I wonder how many footnotes we're going to get here. Defendant's counsel, Mr. Brown, has not withdrawn, and no motion to disqualify Mr. Brown has yet been filed on this matter. Plaintiffs respectfully reserve the right to timely file a motion to disqualify counsel when the issue is ripe. So Saltzy is essentially saying we're not even at that stage yet where we should even be having this discussion. However, we want to reserve the right that if it becomes the issue, we want to be able to file the motion. On January 13, 2021, Ms. Barnhart submitted testimony against defendants' interest. Defendants acknowledged this conflict in the instant motion when they asserted that Ms. Barnhart's first story was plainly consistent with the defendant's interests, and the signed Barnhart Declaration changed that story 180 degrees. Relating to personal jurisdiction, referred herein as the signed Barnhart Declaration, which one shows that defendant KJ Paulson misrepresented the scope and the nature of the defendant's Washington contacts. So up to number 7. Declaration of Catherine Paulson in support of defendant's motion to dismiss. In her declarations filed in support of defendant's motion to dismiss, and 2, establishes defendants have sufficient minimum contacts in Washington for this court to exercise personal jurisdiction over them. We're up to 8. See Declaration of Kim Fulmer, Declaration of Michael Saltz, motion to dismiss, Declaration of Laurie Ann Barnhart. Although it appears from the correspondence between Ms. Barnhart and Mr. Brown, over 150 emails and 2 phone calls, that a reasonable person would have a subjective belief that an attorney-client relationship existed. 150 emails is very excessive, in my opinion. See signed Barnhart Declaration. What do you reckon? If you had a lawyer and you had 150 emails going backwards and forwards, would you assume he was representing you? Because I would. A determination of Mr. Brown's qualifications to remain as counsel in this matter due to his conduct with Ms. Barnhart is premature. Defendant's motion to dismiss regarding personal jurisdiction is still pending before the court. No answer. Affirmative defences, either raised in the motion to dismiss or counterclaims, have been filed identifying the issues in this case, and discovery in this matter is currently stayed. See Joint Status Report and Discovery Plan. Stipulated order, staying discovery. Until the pending of motion is decided to dismiss is decided, the defendants have answered plaintiff's complaint. It is unknown whether Ms. Barnhart, who currently is a witness on the jurisdiction issue, will be deposed or be a witness at trial, subject to cross-examination by Mr. Brown and or another attorney at his firm. There is no need to inundate the court with a motion to disqualify or qualify counsel that may be needless if the court grants defendant's motion to dismiss. Saltzy. Even if the court denies the motion to dismiss, the issue of disqualification, nevertheless, may be moot if the defendants decide not to pursue a lack of personal jurisdiction defence, and there is no other basis to call Ms. Barnhart as a witness to trial. What he's saying there, that if KJ wins the motion to dismiss based on personal jurisdiction, Lorianne goes away. Like, why are we even having this discussion when jurisdiction hasn't even been sorted? Oh, tell ya. Likewise, until defendants file an answer and until discovery is performed, it is unknown whether Ms. Barnhart has knowledge or any non-jurisdictional issues relevant to this case, such that she would be a testifying witness as to those issues at a trial on merits. Additionally, the court does not have all the facts to affirmatively and indefinitely qualify Mr. Brown as counsel. Although Mr. Brown has provided the court with a compendium of his email correspondence, with his email communications with Ms. Barnhart, number 12, Brown Supplementary Declaration, he has not represented that he provided this court with all his communications with Ms. Barnhart. To be certain, Ms. Barnhart provided plaintiff's counsel with additional communications that were not included in Mr. Brown's numerous declarations. Plaintiffs identified at least 2 emails between Mr. Brown and Ms. Barnhart that had not been filed for Mr. Brown. See declaration of Alana Levine in support of plaintiff's opposition to defendant's motion for sanctions. Thus, neither the court nor the plaintiff's counsel can fully evaluate Mr. Brown's relationship with Miss Barnard without all the necessary information. There is no question that Mr. Brown now has a conflict of interest regarding Miss Barnard. The record reveals that Mr. Brown has repeatedly attempted to discredit Miss Barnard's testimony, truthfulness, and mental competency, despite his own efforts to use Miss Barnard for her testimony on behalf of the defendants, as recently as 2 days before the signed Barnard declaration was filed. See Brown's sublimation. So he's put in here pages. We find an objection today. I'd like to include a statement. And he's gone through given page dates, quotes. So he's onto it. Finally, defendants' motion to qualify relies on hearsay evidence. 15. Defendants cannot raise new admissible evidence in their reply. And again, there's some case law here. Finding that counsel may not decline to submit declarations to support a motion, then in reply, provide declarations that counter the opposing party's argument with new allegations. Mr. Brown's correspondence with Miss Barnard and Mr. Brown's correspondence with purported relatives of Miss Barnard. In light of these issues, plaintiffs were not and are not in a position to stipulate to Mr. Brown's request to retroactively remedy his conflicts of interest with his former client, Miss Barnard. So we've got here 16. Mr. Brown also mischaracterises plaintiff's counsel position and statements during his meet and confer on the motion to qualify, and fails to inform the court that plaintiff's counsel told Mr. Brown his mischaracterisation was not the plaintiff's counsel's recollection of what was said during the call, and 2, plaintiff's counsel's recollection was that what plaintiff's counsel represented and that they didn't intend at that time to make motion to the court on that issue. Declaration of Michael Brown in support of motion to qualify. We're going all over the place here. Hello, Erin. How are you going? Oh, this is pretty full on. In light of these issues, plaintiffs were not and are not in a position to stipulate, for those same reasons, the court should deny defendants' motion to disqualify. Clarification of facts. Communication between Lori-Ann and Mr. Brown. Beginning on December 24, 2020, Mr. Brown and Miss Barnard proceeded to exchange nearly 150 emails and 2 short phone calls over the course of 18 days. That is a lot of emails. So here again, footnote. That is a lot. None of those communications established that Mr. Brown advised Miss Barnard in writing that they did not represent her or that he was not providing legal advice. Hey, Gail, I went early because I actually miscalculated my lunch break time. So I really apologize. So I'm sorry, guys. I know it's unusual for people to go early. I know. I'm on limited time. So 18 days is a long time. So again, 150 emails in 18 days. To me, a reasonable person would assume that you had an attorney-client relationship if you were communicating with 150 emails, in my opinion. Okay. None of those. The nature of the approximately 150 emails that have been produced by Mr. Brown reveal that he provided Miss Barnard with legal advice relating to the alleged harassment that he received on Twitter following the filing of the declaration of Kim Fuller. 2, how she should respond to plaintiff's proposed subpoena. And 3, her proposed testimony in support of defendant's motion to dismiss in this matter. Additionally, the primary reason Miss Barnard contacted Mr. Brown was to solicit his services to record to correct the record as to his employment, 18. And again, he's got page numbers, he's got declarations, he's got dockets, and that's a big footnote. In the signed Barnhard declaration, Miss Barnhard testified that Mr. Brown offered to represent her as a third-party witness in this litigation, page 19. I'd like to stand up for you by filing your declaration if you'd let me. It costs you nothing. Miss Barnhard also applies plaintiff's counsel on January 12, 2021, that she believed Mr. Brown was acting as her attorney because she repeatedly asked him for legal advice, which he provided. And again, another footnote, which is all of this. In fact, it goes on over the page. And he offered on multiple occasions to help at no cost. So again, we've got another footnote here. Examples. I have to say, Saltzy is not thorough. Mr. Brown also dissuaded Miss Barnhard from contacting plaintiff's counsel directly. For example, on December 30, 2020, at 5:55 p.m., Mr. Brown wrote in relevant part, I spoke with Saltz today. They are planning to subpoena your Twitter account because they see that you have closed your account and they think there might be evidence about your connection to Katie. I did not disclose that you and I are in touch. Saltz even complained to me that you threatened him in a DM. So, Brown supplementary declaration. At 6:18 p.m., Miss Barnhard responded, figures, what are your thoughts? 23. Notably, this email was not provided by Mr. Brown in the multitude of his previous filings with the court. Oh, that's sass. So I said, I'm here for the sass. I like it. At 6:22 p.m., Mr. Brown responded, I'll have to think about this. For the time being, it's best for you not to make any contact with Katie and vice versa. They're working hard to try and paint you two as a team, and that's not good for either of you. Number 24, Brown supplementary declaration. At 7:16 p.m., Miss Barnhard responded in relevant part, maybe it would be easier if I went and met with Saltz myself. He can see me face to face and see that I am no threat and I have nothing to hide. I actually present myself very well and know how to be professional when I need to be. Don't worry, I will not say nor do anything without telling you first. 25. There we go. So on December 31, 2020, at 6:37 a.m., Mr. Brown wrote, I understand that impulse, but you need to understand the type of person he is. Do you have the ability to pay for your own lawyer to help you if they do issue a subpoena? Again, it is unclear if Miss Barnhard responded to the above email, as the record is devoid of such a response. Yeah, on December 31, 2020, Mr. Brown wrote, you'll get a copy of the subpoena if they issue it. If it asks just for communications with Katie, then it sounds like there won't be much to it. If it's too broad, like asking for all your tweets, you can challenge it. So we've got to scroll down 27, again down here. It's interesting, though, how he calls Katie, because usually when you're dealing with a legal case, you would refer to them by their legal name. It shows that he has, in my opinion, it shows there's a more intimate, well, he did refer to her as my Katie before, hey. But I just find it all very interesting. Mr. Brown also convinced Miss Barnhard on at least one occasion that she did not need to consult with separate counsel. On January 8, 2020, at 5:35 p.m., Miss Barnhard wrote in relevant part, I used to volunteer for Snohomish County Legal Services. I apologize, I've just stuffed that up. I can't pronounce it. It says, notably, Snohomish County Legal Services is a free legal aid program. Thus, Mr. Brown's attempt to explain that his statements to Miss Barnhard were to reassure her that she did not need to spend money in responding to the subpoena is misleading. Official website, the City of Washington, there's a website there. The court may take jurisdiction notice of this fact because it is a fact not subject to reasonable dispute and is available from a reliable source. Oh, wow. It's gone. At 5:41, Mr. Brown responded, "What help do you think you'd need from a legal service?" Number 30. At 5:48 p.m., Miss Barnhard wrote in relevant part advice, number 31. That's in the sealed second supplementary declaration of Michael P. Brown in support of defendant's motion to dismiss. So, advice. This is something that we didn't know. But LA, oh, hello at the Amber Chick. Hello, everybody. Bam. Hello, Just Brit. Yeah, I've come on just to read the legal documents, and then I'll be back to my nocturnal life. At 5:56 p.m., Mr. Brown responded in relevant part, "I understand you really have nothing to worry about with this. You've done nothing wrong. I think I can help you with the response for no charge. It's very simple." Brown declaration. On or around January 11, 2021, Miss Barnhard terminated her attorney-client relationship with Mr. Brown. 33. All right. I haven't seen how many footnotes there are, but do we want to have a run-in if anyone knows? But does anyone know how many footnotes there are here? I'm up to page 8. I'm up to 33. And my cats are crazy at the moment too. Anyone want to have a guess how many footnotes we're going to get to? Because we're about to hit 34 on page 8 of 17. I think the record's 94, but I don't think we'll get 94. On January 13, 2021, the signed Barnhard Declaration was filed. So on January 22, 2021, Mr. Brown filed a supplementary declaration in support of defendant's motion to dismiss, in which he purports to characterize his communications with Miss Barnhard and accuses Miss Barnhard of filing false statements under the penalty of perjury. 35. Brown declaration. Mr. Brown also attached the relevant emails. Up to 36. With Miss Barnhard, nearly 200 pages for public review and consumption. 37. Mr. Brown withheld those containing especially sensitive health information and purported to provide such emails in his second supplementary declaration. 38. This keeps jumping on me. It remains unclear whether all of Mr. Brown's communications with Miss Barnhard has been provided. All right, so up to the argument now. So I'm sorry, this is just jumping around. 70 or 80? Yeah. Talks about everything. Cool. All right. Argument. Motion to strike. Defendants again rely on hearsay evidence and 3 unsigned declarations prepared by Mr. Brown collectively, unsigned Barnhard declaration, to support the instant motion. Up to 39. And again, he's put dockets, page numbers. It's very detailed. Plaintiffs previously moved to strike this evidence in their opposition to defendant's motion for the sanctions pursuant to Local Civil Law 7G and the Federal Rules of Evidence 801 and 802 and the Local Electronic Filing Procedures at Section L 28 USC and 1746. Plaintiffs reiterate their previous motion to strike. Although Ms. Barnhard's own prior statements might be used for impeachment purposes, on cross-examination. If Miss Barnhart testifies at trial, such evidence is inadmissible to support a motion. On a motion to dismiss for lack of personal jurisdiction, the court does, I've got to scroll down the whole page, not weigh the credibility of witnesses, and factual disputes are resolved in favour of the plaintiff. So what he's saying is what everyone else is saying, that everything, it works in their favour. All right. Although potential conflict of interest and ethical issues plainly exist, disqualification is not yet ripe. Attorneys practicing in the Western District of Washington must abide by the rules of the professional conduct as promulgated and interpreted by the Washington Supreme Court. Okay, so we're up to 41 now. So we might get to 70. Yep. The court retains responsibility for controlling the conduct of the lawyers practicing before it. We're up to 42. And he's citing legal cases. Non-client litigants may, under proper circumstances, bring motions to disqualify counsels based on conflicts of interest where an unethical change of sides was manifest or glaring, or an open and obvious ethical violation which compels the court to exercise its plain duty to act. 43. Mr. Brown's disqualification or qualification is not yet ripe. It sounds like fruit, doesn't it? It's not quite right yet. This is what we've been saying all along, is that we have no idea if Lori-Ann is even going to be needed. So why are we even talking about this issue yet now when jurisdiction hasn't been done? While a motion to disqualify counsel may ultimately be necessary, defendants' instant motion to qualify is premature as well as improper, and the requested relief that the court enter an order finding that no grounds exist to disqualify Mr. Brown and or his law firm, another footnote, we're up to 44, is overbroad. Defendants' effort to preemptively obtain a ruling on Mr. Brown's disqualification due to alleged concerns about plaintiffs' using the issue as a litigation tactic are misguided and fails to show ripeness. Contrary to defendants' assertions, defendants are not being forced to proceed under the constant threat that the plaintiffs will choose some strategic time in the future to make the disqualification motion, 45. Rather, it is Mr. Brown's actions that have created the situation in which the defendants find themselves. And it is the defendant's motion to dismiss and their agreement to stay discovery that make the disqualification issue not ripe. So he's saying it's Brown's fault. See defendant's motion and stipulated stand order, because the order says that nothing else really can happen. Promote. I know. Gotta love Google. Moreover, so what he's saying, because it's discovery, nothing happens in discovery until the issue with the issue of jurisdiction is taken place. We haven't had jurisdiction. We have no idea whether Lori-Ann is actually going to need it in discovery or whether she's going to be needed for a witness. So what are we talking about this for? Like, hello? So the disqualification fruit is not yet ready to fall yet. So what's happening is Saltzy is saying we may get to a point where they have to apply for him to be disqualified. However, we're not there yet. Kiki Ray says this explains her hate-filled rants of past. Oh, I would say so. I would say this explains her rants. I would say that there has been a conversation that Saltzy's been on the phone or email or whatever, and they may have seen it beforehand, and she may know what's coming. Moreover, Washington law prohibits the use of motions to disqualify as litigation tactics. A motion to disqualify must be filed with reasonable promptness after a party discovers the basis for an alleged conflict, and failure to do so may result in a waiver of the objecting party ability to bring the motion. 47. So he's starting case law. Hello, Sarah loves donuts. Shyla, yeah. Yep. We all knew she was coming unhinged, and we all knew it was coming. We just didn't know what was coming. Delaying in filing a motion to disqualify is suggestive of its use for purely tactical purposes and could be the sole grounds for denying the motion. So up to 48 in footnotes. Here, plaintiffs have not delayed filing a motion to disqualify because the disqualification issue is not yet ripe. Plaintiffs first became aware of a potential issue of disqualification on January 12, 2021, which was after the defendant's motion to dismiss was filed on December 2, 2020. Depending on the court's ruling on the motion to dismiss, defendants' litigation decisions, i.e. whether defendants continue to pursue a jurisdiction defence and on what defendants put at issue in their anticipated answer, assuming defendants file an answer, Mr. Brown's qualification or disqualification as counsel in this matter may not be rendered moot. 49. Finding no undue delay for a 6-month gap between the beginning of a lawsuit and filing motion to disqualify because the issue of disqualification was not yet ripe until the district court denied the defendant's second motion to dismiss claims seeking to rely on testimony of former client. Because the thing is, right, what they're saying, this is my interpretation, remember, I'm not the lawyer, is that if KJ was to win on jurisdiction and, for example, they moved the location, Mr. Brown's a Washington lawyer, they don't need Mr. Brown anymore. Mr. Brown's gone. So why are we having this discussion now? Why are we having this discussion now? This is what Saltzy is saying. We don't know because we don't have the ruling on jurisdiction. We don't know what way they're going to go. We don't know what the next moves are because we haven't had that decision. And so why are we talking about something that if they file the motion in Minnesota, Mr. Brown's not going to be on the case? Like, hello. Mr. Brown, in my opinion, has acted like a bit of a drongo. He tried to jump the shark but missed. Additionally, discovery has been stayed on this matter until the court rules on motion to dismiss. And until discovery is conducted, plaintiffs cannot ascertain whether Ms. Barnhard would be a testifying witness regarding jurisdiction or non-jurisdictional facts. Like, hello. Well, yeah. Or whether Mr. Brown is in possession of a proper written conflict waiver signed by the defendants and Ms. Barnhard, contrary to her testimony. It all comes down to jurisdiction. In addition, even if the disqualification issue was right for consideration, a delay of less than 3 months while discovery has been stayed and no substantive motion practice has occurred or can occur until the court rules on the pending motion to dismiss. It is not unreasonable grounds nor grounds for denying a motion to disqualify. So we're up to 52. So another one there. All right. Mr. Brown and Ms. Barnhard appear to have formed an attorney-client relationship. An attorney-client relationship exists, and we're up to page 11, when the conduct between an individual and an attorney is such that an individual subjectively believes a relationship exists. 53. So again, more case law. The client's subjective belief, however, does not control the issue unless it is reasonably formed based on the attending circumstances, including the attorney's words or actions. I think he's done. And when I say I think Brown is done, I think based on his words, there was a attorney-client relationship. Because why else would he say, I want to stand up for you, if he wasn't going to act as her lawyer? A court must have the facts of what actually occurred between the two parties in order to determine the legal question of whether the parties established an attorney-client relationship. So we got to 55, more case law. An attorney-client relationship may be implied from the parties' conduct if it need not be memorialized in writing. Harrison's going to love it. Or I can tell you that. Okay, here, Harrison is going to love it. An attorney-client relationship may be implied from the parties' conduct. It need not be memorialized. Oh, I just said that. Sorry, I got distracted by Harrison. Washington courts have held that even a short consultation meeting or conversation may create an attorney-client relationship. Wow. That's interesting. Here, Miss Barnhart testified that she had an attorney-client relationship with Mr. Brown. Defendants even sought sanctions against plaintiffs' counsels for violating RPC 4.2 when they spoke to Miss Barnhart. Remember, Brown said in one filing he wasn't her lawyer, and then he brought sanctions against Saltzy because he didn't ask permission because he was her lawyer. Additionally, Mr. Brown has advised the court on more than one occasion that he and Miss Barnhart exchanged nearly 150 emails and 2 phone calls over the course of 18 days. We're up to footnote 60. Well, Mr. Brown only cites two emails, 2 from Miss Barnhart in the instant motion to qualify. The breadth and nature of the available correspondence as a whole appears to support Miss Barnhart's reasonable belief that Mr. Brown represented her. For example, the available correspondence shows that Miss Barnhart repeatedly requested Mr. Brown's legal advice as early as December 31, when told Mr. Brown that she would not say anything without telling him first. So we've got 61 and 62. And again, we've got dockets, we've got page numbers, we've got quotes. Footnote 60, we're up to footnote 63. You might be right, Gail. Mr. Brown repeatedly offered Miss Barnhart's legal advice. Mr. Brown actively dissuaded Miss Barnhart from contacting the plaintiff's counsel directly. Miss Barnhart indicated to Mr. Brown on at least 4 occasions that she was inclined to contact the plaintiff's counsel directly. Oh, sorry. See? This is why I don't do daytimes. However, Mr. Brown convinced Miss Barnhart not to do so. So here we go. Look, all of the quotes. So really whoever reads this can go back and check all the dockets and everything, but all the words are there. Look at that. I understand this is very stressful. You should at least speak to me about it. Yeah. Wow. Based on the proceedings examples alone, Miss Barnhart's subjective belief that an attorney-client relationship existed with Mr. Brown believes to be reasonably formed. Mr. Barnhart terminated such an attorney-client relationship on January 11, 2021. So up to 66. 66. Yeah, I know. Harrison tried to give away. Apparently, the thing is, I'm supposed to buy a new one, but I don't know what with. Oh, Mr. Brown, whatever you were thinking. Yes. So KJ is going to get stuck with all the Brown's bills and then have to hire her. Well, that is only if KJ was to win jurisdiction, that is exactly what's going to happen. If Tardy then decides to take it to Minnesota, that's exactly what's going to happen, Kiki. At the very least, Mr. Brown and Miss Barnhart formed a prospective client relationship. Even assuming Mr. Brown and Miss Barnhart did not have an attorney-client relationship, Miss Barnhart appears to be, at the very least, a prospective client to whom Mr. Brown owed certain duties. Rule 1.18 of Washington Rules of Professional Conduct which establishes the duties owed to a prospective client, is the applicable rule here. The rule provides, in relevant part, a person who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter is a prospective client. Even when no client-lawyer relationship ensures, a lawyer who has learned information from a prospective client shall not use or reveal that information except as Rule 1.9 would permit with respect to information of a former client, or except as provided in paragraph E. A lawyer subject to paragraph B shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter if the lawyer received information from the prospective client that could significantly harmful to the person in the matter, except as provided in paragraphs D or E if a lawyer or LLT is disqualified from representation under this paragraph of LLT RPC 1.8, no lawyer in a firm or lawyer in which that lawyer or LLT is associated may knowingly undertake or continue representation in such a matter, except as provided in paragraph D, 67. I'll try and explain that to you as I see it. This one here says that if she was a prospective client, if she had said, if she had information that was going to be adverse to KJ, he wouldn't have been able to represent her. Now, her signed declaration was actually complete opposite of what the unsigned was. So therefore, he couldn't represent her anyway. That's my interpretation of that rule. Whether communications, including written or oral or electronic communications, constitute a consultation depends on the circumstances. For example, a consultation is likely to have occurred if a lawyer, either in person or through the lawyer's communications in any medium, specifically requests or invites the submission of information about a potential representation without clear and reasonable, understandable warnings and cautionary statements that limit the lawyer's obligations. And he did not do that. And a person provides information in response. In contrast, consultation does not occur if a person provides information to a lawyer in response to a communication that merely describes the lawyer's education experience, areas of practice, contact information, or provides legal information of general interest. So what he should have said was, Lorianne, I can give you some advice on this. However, I'm not your lawyer, or I can give you general advice. If he had written that anywhere, he would have been safe, but he didn't. He's got himself in some poo, Mr. Brown. Here, Mr. Brown and Miss Barnhart exchanged nearly 150 emails over the course of 18 days. At no time has Mr. Brown submitted to this court evidence or argument that he sent an email to Miss Barnhart that contained any clear or reasonable, understandable warnings and cautionary statements that limited his obligations to Miss Barnhart. That's essentially what I just said. Instead, Mr. Brown made numerous requests and repeatedly invited Miss Barnhart to submit information about herself and the matters at hand. And we're up to 68. Oh, I can see what we go down to 74 at least. Miss Barnhart disclosed substantive and confidential information to Mr. Brown that could be significantly harmful to her, 69. Mr. Brown, therefore, may be barred from using Miss Barnhart's confidences against her and barred from representing defendants who have adverse interests in the same matter. So this is where he's got himself in the poo. The record reflects a significant conflict of interest. So now we're saying that Saltzy is showing, hey, there are issues here. But remember, these issues will only exist if Lorianne is required. While plaintiffs have not yet moved to disqualify Mr. Brown and his law firm due to the disqualification issue not being ripe, it is apparent that a conflict of interest exists, such as the defendant's motion to qualify may be denied. And the other thing that Saltz is really hammering down here is that it's his side that files the motion. It's up to them, the defendants, to decide whether to file the motion, whether there's a conflict of interest. It's not up to Brown. And then the armchair attorney, it has always been such to me that our line, we're ever communicating, a line crossed right from the start. So, because he keeps saying, well, the plaintiffs have not yet moved to disqualify Mr. Brown. He's saying it's our job to decide that. It's not Mr. Brown's job to say, keep me going. It's their job. So now he's saying, well, there is a conflict of interest, but we haven't decided. We're not going to do anything until we know what we're playing, what's at stake, what's happening. Because what happens if, let's just say Brown is allowed to qualify and then the case goes to Minnesota? What a waste. Mr. Brown asserts that his communications with Miss Barnhart were for two purposes. One, to explain the abusiveness of the formal declaration, and two, to confirm defendants' statements that they did not know Miss Barnhart resided in Washington until that fact was disclosed in a lawsuit, number 70. I'm actually going to do a video and take you into my analytics. I might do this tonight when my son's at youth group, to show you how you can actually work out how much money you get from a certain state in the US and how a certain someone would have known exactly how much money they received from Washington. However, Miss Barnhart's testimony submitted on January 13, 2021 states that, among other things, Miss Barnhart's testimony that Miss Former's declaration was accurate with the exception of where Miss Barnhart allegedly worked. Defendant Paulson did, in fact, have reason to know Miss Barnhart resided in Washington by at least April 2020, if not earlier. And 3, defendant Paulson misrepresented the nature and scope of defendant's Washington contacts in her declarations filed to support motion to dismiss. Whoopsies. You reckon that would be interesting? I thought that would be interesting. The problem is I don't have a lot of data because I've just become monetized, but I can it definitely shows you, and it takes about 48 hours for it all to appear, but I can show you at least how it works. Right, up to page 15. Hello, Michelle. Notably, Miss Barnhart's testimony centres on the same issues Mr. Brown admits were the subject of his former representation, and her testimony is not favourable to Mr. Brown or his current clients. Here, the only interest even hinted at in the second Barnhart declaration is Miss Barnhart's alleged possession of information that contradicted testimony Miss Paulson provided in support of defendant's motion to dismiss. In fact, Mr. Brown alleges that Miss Barnhart's testimony in the signed Barnhart declaration changed the first story she told him by 180 degrees. The 150 emails exchanged between the undersigned and Miss Barnhart over the previous 18 days were perfectly consistent with the unsigned Barnhart declaration, which she was eager to sign under oath, and contradicted the testimony they were putting in front of her in the signed Barnhart declaration. That Mr. Brown contends Miss Barnhart's testimony is now in the opposite position is enough to establish adversity. The crux of the adversity inquiry centres on the lawyer's duty of loyalty. Parties are allowed to switch sides. Lawyers are not. Whoa, that's a big one. The underlying question is whether the lawyer was so involved in the matter that the subsequent representation can be justly regarded as the changing of sides in the matter of question. Loyalty and independent judgment are essential elements in the lawyer's relationship to a client. Concurrent conflicts of interest can arise from the client's responsibility to another client, a former client, or a third person from the lawyer's own interests. Unforeseeably, developments such as realignment of parties in litigation might create conflicts in the midst of representation. So what they're saying is that a party can change sides, but he can't. So, yeah, he's in a bit of trouble by the look of it, Mr. Brown. Not only is Miss Barnard's testimony unfavourable for the defendants and Mr. Brown, but also in nearly every one of the defendants' filings since January 13, defendants and Mr. Brown have attempted to use Miss Barnard's communication with Mr. Brown to discredit her, accuse her of submitting false statements under the penalty of perjury, and or allege that she did not have the capacity to execute the assigned declaration. And again, he's gone through and he's listed every single one of them. Moreover, if and when this case proceeds, I love that, if and when. If and when. I like that. If and when this case proceeds, Mr. Brown may need to cross-examine in a deposition or a trial Miss Barnard about the exact same issues. Hang on, I've just got to do something. If and when. I know, if and when. I love that. If and when. If and when. Bam. There's our bomb. So he may need to cross-examine Miss Barnard about these exact same issues, including issues raised in confidence during the attorney-client relationship for the sole purpose of trying to create doubt as to whether Miss Barnard gave truthful testimony in the signed Barnard Declaration and or is a competent witness. Further, if Miss Barnard testifies at a trial on any facts not favourable to defendants to represent Miss Paulson to the best of his ability, Mr. Brown must attempt to discredit that testimony. That is, again, it is in the defendant's best interest for Mr. Brown to try and create doubt as to whether Miss Barnard is competent to testify and or convince a jury that she committed perjury when she testified against defendant Paulson. Accusing a former client of either incompetence or a crime to benefit another client in the same matter could not be a clearer conflict of interest. Therefore, Mr. Brown and his firm cannot exercise their duty of loyalty to both Miss Paulson and Miss Barnard in the matter. Hello, Dominus. Cool. Oh, you got to hear at the end. So for the foregoing reasons, plaintiff respectfully requests that the court deny any defendant's motions to qualify. So to sum up, everything that we've said before is that he's just put a hello, Phyllis. Hello, Dom. Hello, everybody. Yeah, I just finished. So essentially, in 17 pages, what he has said is that we have no idea whether there is an issue yet because we haven't got jurisdiction. Now, if Mr. Brown is right and there wasn't a client-attorney relationship, at worst, it's a potential client relationship, which Washington has upheld at times. And, oh yeah, the footnote count. And that there is a conflict of interest, because how can he represent Miss Paulson? What? So that's 80. So what they're saying is, in order, if in order to discredit Miss Barnard, or he's going to have to discredit Miss Barnard in representation, and yet she could be a former client of his, and that's not very professional. So that he has a conflict of interest anyway. So they've got a proposed order here denying it, because, as he said, we're not at that point yet. So this is just here, is denied. So it was pretty sassy, though, in my thoughts are. It was pretty sassy. She did a video an hour ago where she tore shreds off. She did a video just before I came. She had a video up just before I came online because I did check. And she ripped into a roll-off. She's accused them of stealing money. 3 hours ago. It's called Liars. Jeremy and Audrey Roloff received $53,000 in bailout money. So, yeah. You demand a replay at... it was a pre-recorded one. I don't think she's been live. I think Brown knew what he was doing, like how he told her she'd need to have a lawyer if she was subpoenaed. I know. Well, you know what? There's a part of me that's going, has Brown done this to get himself off the case? Is lawyer incompetency the only way he can save himself from being totally riled, like totally destroyed? I know, it's very confusing for me. And as I said, my phone keeps ringing. So, yeah. It's very confusing. So anyway, I've just about finished my lunch break, so I actually have to go. I've got to go back. However, so what I'm going to do, so my son's at youth group, so I don't even know that I'm going to get live today. However, while my son's at youth group, I'm going to show you my analytics and show you how a certain person would know how much money they got from Washington in a certain amount of time, because I found it myself. But interesting, I don't have any income from Washington. Oh, Frank says, I want to thank you again for your video. This I am responding to Kaja. Oh, not a problem, Frank. She was so angry. I was so angry. And once I had calmed down and had thought about it, I thought it was the best way to deal with it. So anyway, so thank you. It's been interesting. Anyway, I hope that has helped. I know Uncivil Law's just gone live. I know he's just gone live. But it's a talking point. But I think it explains why someone's been totally and utterly out of control the last few days. And also the Instagram, I don't have memberships yet, Sarah. No, I don't. As soon as they do, I will do. So anyway, either way, there'll either be a pre-recorded video or there'll be a live later today, but I won't know. Wait, does that mean? Yeah, I'm not sure, Frank. I really don't know. I would love to tell you. But what I might do is I might set the video to go at the normal time I'd go live anyway, so that you've got something to watch. So you don't have to have a full. But it'll be a breakdown video of the YouTube analytics using my... And bearing in mind, I've only been monetized for less than a week. So some of the information will be very new. But it is very interesting to find out what states your money's coming from. And, yeah. But I'll do a video to break that down. Anyway, I have to run. I would love to. I hope I've explained it as best as I can in this. I've tried to break it down into everyday speak for you. Anyway, have a great day, evening. You know what, Michelle? Okay, that would be a really good idea. Yes, I can do that, Michelle. What a great idea. So I'll do it as a premiere. Yeah, I'll do it as a premiere. So I'll set it for, and then it can be, everybody can do it. But I probably will film parts of it during parts of the day, because I will actually get little breaks from now until later. So there may be, and I'll just have to put it together. But yeah, I'll do it as a premiere for you. Great idea, Michelle. All right, catch you all.